All right, we're going to go ahead and try to get started. Welcome to Carpenter Hazlewood. We call this seminar Condo Summit. We're going to do this a little differently today. We've got a number of different topics we want to cover. And if you're watching online, welcome to this seminar. If you're watching this seminar because of it being in our library, this information is effective on February 14th, 2013. If you're watching this in the year 2020, we're not sure that all the information is still going to be correct, and hopefully it won't still be on our website by then. But we're going to cover a number of different condo-related issues today, and we're going to do it in a somewhat interesting fashion. We're going to do this in a manner that we call audience-directed. You are going to interact with us and steer the conversation, not just by how you verbalize responses and how we interact on that, but we're going to use our clickers. And so I'll explain a little more on that later, but we do want to start with a particularly important topic that comes up a good bit and has to do with transition, developer liability, and the way that associations need to transition the process. And to do that, I've asked my partner, attorney and partner in the firm here, Richie Lipson, to come up and cover a few quick topics here at the beginning. Richie.
Thanks, Scott. Hi, I'm Richie Lipson, and I'm the construction defect partner at Carpenter Hazlewood. I want to talk just briefly about some things that come up in our area of practice and is really relevant to condos. And a lot of this is review, but I think it's important to be covered. So the first important thing we talk about when I present to boards is about their duties that they have. First one is to act in good faith, use ordinary care and prudence, and act in the best interest of the condominium. We all know about the ARS provision. Boards have an affirmative duty to protect the assets and pursue responsible parties, and we'll talk more about that in a minute. And, of course, maintain the common area. The common area is the single biggest asset. Condominiums, of course, a lot of common area, right? And then there's been recent case law recently about, and in fact we're defending numerous associations about the duty to enforce mandatory provisions in the CC&Rs. As managers, obviously you want to ensure that the boards comply with their duties. You guys are agents of the condo. Report maintenance history and problems to the board. Ensure the common area is maintained. Bring in appropriate experts where you need to. And also to avoid liability, relying on those outside experts for advice. So a little bit more in review. What's a construction defect? Construction defect, obviously we have three different categories. A defect in workmanship, where we see a violation of applicable building codes. Deviation from plans that are provided by the builder. And then there's this standard of care in the industry. The Registrar of Contractors provides standards for stucco subs, how much acceptable cracking you can see in stucco, how big, how frequent, all the different trades. There's actually a standard of care manual published for each individual trade. Then we have defects in materials. When a builder has windows delivered, there's instructions inside how they should be put together. When roofing components are delivered, the roofing manufacturer has different specifications and standards by which the roofing material should be installed. If you fail to follow those manufacturer recommendations, that's a construction defect under the law. And then there's design issues. Sometimes the structural engineer can make a mistake. The civil engineer can make a mistake. The architect can make a mistake and actually design some component incorrectly. We had a lot of cases a few years ago where the slabs were designed to move up and down but couldn't withstand the movement of the expansive soil. So it was actually a design issue that the structural engineers came up with, and there was a lot of lawsuits that came out of that. Now, the biggest development we've seen in construction defects in the last, say, 5 or 6 years is these affirmative obligations in the CC&Rs that require you to do an annual inspection by an independent third party. Sometimes they're buried in the maintenance section. Sometimes they're in just all alone in a section by themselves. but it's an affirmative requirement to bring in an outside independent expert and issue a report of the status of the community in terms of what maintenance is due, what maintenance is deferred, and then issue that report to the members. And some of them some are very detailed. We have one client that was spending over $40,000 a year to do this report on an annual basis. So it depends on the scope of them. The other things we're seeing in CC&Rs are provisions that provide that at time of turnover, the developer has provided a maintenance plan. And if you fail to follow that maintenance plan that was provided by the developer, all your implied and express warranties are void. So it's pretty draconian provisions that we're seeing in the CC&Rs, and sometimes they're just buried in the oddest places. So it really would behoove you to take a look and see if you have this duty to inspect provision or this maintenance obligation to comply with the maintenance manuals that's been provided by the developer. And then our firm also recommends as a best practice that you obviously inspect your community on an annual basis. Every CC&R has, or most of every CC&R has a provision that provides for you to do an annual budget, and that you're going to reserve and assess based on that budget. And without inspecting the community and having a report of really what maintenance is due, it's very difficult, obviously, to do an accurate budget. So we call that the super best practice, right? Scott loves that. We have a duty to inspect program at Carpenter Hazlewood where we'll send out, when there's construction defect claims, we generally don't have to look at 100% of the units. We don't have to look at every interior, every building. We can look at a percentage of the buildings and then extrapolate out. So if a window is defective in one unit and we test 10 and they're all defective, then we can extrapolate out to the rest of the community. Same thing goes for the duty to inspect. If you look at a portion of your buildings on an annual basis, we think you satisfy that duty to inspect requirement in your CC&R. So our program is to send out a licensed general contractor, spend a day in your community, issue a full report, which we have samples on the table when you leave today. You can take a look at the reports. And then we'll write you a letter saying you've complied with the duty to inspect provision. So as a board or as management company, you're protected against potential liability down the road. So it's a great program. $1,000, we'll send out a guy for a whole day and issue a full report to the community. And then one other review for construction defects is the statute of limitations. In Arizona, you have 2 years from date of discovery of a defect, and that date is when you knew or should have known of the problems. And of course, if you have a leaking roof and you get in a claim, the other side is going to argue that the time you had the leaking roof is the time you're on notice of the defect. So you have 2 years from date of discovery for negligence. The second, ARS 12548, is what we call the implied warranty of habitability and fitness. And that is a 6-year statute of limitations from the date you knew or should have known. So both the blue line and the green line kind of slide based on when you knew or should have known, when the clock starts ticking. Now there's an outside date called the statute of repose in Arizona, and that's 12552, which is a absolute drop-dead date by which you can bring a claim for construction defects. That's 8 years from substantial completion by building. So the 6 years obviously could be less than the 8 because it moves from date of discovery, but that drop-dead date of 8 years is for substantial completion. Now, if you discover the defects in the last year, in year 8, you get a bonus year, and it makes it 9. So if you discover defects in last year, you get 1 extra year. In today's environment, there are a lot of subcontractors, a lot of general contractors, a lot of developers have gone out of business. We all are aware of that. If you have construction issues and you're coming up on that 8-year statute, there's still claims to be brought if the developer or general contractor or subcontractor are out of business. They generally have insurance in place, and that insurance still has a duty to defend and step up and potentially pay the association for defects, even if they're out of business. So if they're out of business, that doesn't necessarily defeat your claim. The second thing that we see a lot is guys are still in business. They're still out there. They're still operating. You may have a business relationship with them, but there's defects in the community. In Arizona, there is a couple things that are happening. There is a statute called the Purchaser Dwelling Act, which allows people to come back and make repairs and investigate repairs with the community. There's also provisions in your CC&Rs that are what we call alternative dispute resolution provisions, which again give builders, general contractors, and often subcontractors the right to come back, investigate, and make repairs. We have a number of cases now where the developer's gone out of business, but the general contractor's still in business, and we're working through repair scenarios with them where they're making full repairs to the defects that have been found in the community. So that's usually fairly painless and gets done fairly quickly. So that's a good thing if they're still in business. But if you're getting close to the 8 years, we're all aware of what's going on in Arizona with some plaintiff firms out there these days. There's a single, if you miss that statute of repose deadline, you're done. And it could be very expensive to the association. So it's something you want to make sure you have an inspection done if you're getting close to the 8 years. So, Scott?
Thanks, Richie. Okay, so at this point, audience-directed seminar means that I'm going to put 5 topics up on the screen, and you're going to use your clicker, the white device in front of you, to pick which ones you want me to talk about, which ones we want to discuss today. And we'll do this twice. So we're going to put 5 up, and I'm going to give a little more explanation of what the topic is rather than the first few words up there. But in order to vote, you have to turn on the power to your clicker, which is the bottom button. And if you can see it in the dim lit room, there's an A, B, C, D, and E on there. So you have to be able to turn it on. And if you have a blue light, you're ready to go. And so I'm going to put these 5 topics up. Pick the ones you want to talk about, and we'll talk about the top 3. Okay, so here we go. First one is pass-through assessments. This deals with the question of what expenses the association incurs can be passed through to the owners specifically. In other words, some expenses incurred by the association. Under what circumstances can you force that entire expense through to one or more owners? And under which circumstances are you obligated to? So we'll call that the pass-through assessment. That's option 1. Option B is disabled owner parking spaces. Disabled owner in a condo comes to you and says, I want a space closer to my unit. Are you obligated to provide it? That's the second topic. Pretty interesting. The third one is assistive animals, emotional support animals, disability supporting animals, and what to do in condos where you might have a regulation about weight of dogs or whether you can have canaries or something like that, and somebody claims that it's assisting them. The fourth one is what we'll just call insurance claims and issues. It's somewhat broader, but deals with a number of issues that come up with insurance in condos. And the last option for this round is who maintains what? Who maintains what?
Do we only vote for one?
You can only vote for one. Each clicker only has one code. You can change it multiple times. You can hit it 100 times. It won't matter. Each of these remote controls has a different serial number or code, and the system's only going to log your vote one time. I've done this before where I've seen people sitting in the back hitting it as many times as possible to try to manipulate the result, and it won't happen that way. All right, while you're voting, I will tell you, interestingly, about this technology. It's used in a number of schools and colleges where professors hand out these and they assign the serial number to a particular student, and they can then do pop quizzes and log the information in an interactive way. So it's pretty cool stuff. All right, there are more than 33 people in the room, but you snooze, you lose. So 10 more seconds here. We'll see if anybody else wants to vote, and then we'll see where we're headed. Okay, you all asked for, gosh, close one. No disabled owners and no assistive animals. We will not be covering that today. That will have to be saved for another day. But we will do pass-through insurance claims and issues, and we will also cover who maintains what. Okay, so you have a handout in front of you, and you can put a big X through the second 2 topics. Those will be saved for a different day, or if you have issues with that, call us and we'll certainly be willing to help. But we will cover then pass-through assessments, and then we'll go to insurance claims and issues, and then who maintains what. And then we'll do it again, and we'll see where we end up with the time we have today. I love to be interactive, so I'm going to cover a few points with each of these, and then I'd like for you to interact, ask questions, make comments, disagree with me, argue. Just don't rush the stage and try to take me out, because I'm not much of a fighter. All right, so when we talk about pass-through assessments, this actually turns out to be a somewhat complicated issue, although it probably shouldn't be. But in the application of what we do with certain expenses, sometimes owners and board members get themselves kind of tangled up. So to start this topic off, I would invite you to look in the spiral book in front of you, the statute book. We're going to simply go to page 98. We're just going to study the law in its organic form. What does the statute actually say? And it's a little bit of exposing but what's behind the curtain around here, because there's always the mystery of what the law says, but we're going to try to demystify it today. So as it turns out, the law in Arizona in the Condominium Act basically says to a developer, you can do whatever you want to in your documents. You can create whatever rules you want to with whatever you want to do with the expenses of the association. So if you want to set up a situation where under every circumstance, every unit owner pays 1/100th of the expenses, no matter what they are, all the time, every time, you can do that. And that's what most people think of when they think of a condominium. Hey, we all agreed to share. There's 100 units, so we're all going to pay 1/100th. The fact that some units are bigger or smaller than others is irrelevant. Footnote, some associations do allocate by square footage, and that's appropriate. For sake of my discussion, though, we'll say it's 1/100th. Everybody pays equally. And part of the challenge is that that's what buyers think, too. So we have board members who think that buying in a condo means that every expense, no matter what the species, no matter what the type, no matter what the cause, is always going to be distributed 1/100th. And let's admit, although no showing of hands, please, let's admit that's easiest. You just take every expense, lob it into the community at 1/100th, and everybody pays equally. Now, for management, that might be easy, it might be difficult, depending. We won't get into that. But for board members, there's a kind of efficiency, it's a kind of simplicity to this whole thing. And for the owners, it sort of makes sense too. So you have an event that comes along that costs the association $10,000. Let's say lightning strikes one of the buildings, takes out the roof, and there's a small fire, and it's a $10,000 repair. And let's assume for the sake of discussion, for the moment, hypothetically, there's no insurance. So you have a $10,000 expense. A lot of people would say, well, you know, that's an association expense. Let's take the $10,000, we'll fix it. Take the $10,000, push it into the 100 unit owners, they'll each pay their share, and then we'll move on. And why does this work in general? Well, I think I've kind of figured out partially why. The owners who would otherwise get upset about it are basically thinking two things, one consciously, one subconsciously. Their conscious thought is, well, it wasn't their fault. It's an act of God. That's horrible. They're my neighbor. Seems fair. The association has maintenance obligation with the roof and the exterior. It costs $10,000. That's okay. That's their conscious thought. The subconscious reinforcement of that is, one day that might happen to me, and then I won't actually have to pay the $10,000. The association will be there for me. There's been a precedent set. And although I might complain about the fact that I'm contributing my pro rata share to this $10,000 expense, I'm sort of okay with it because I conclude in my mind the association will be there for me one day. And if I ever need them in a similar situation, I'll have them. And so the board members are owners too. They basically mirror these attitudes that exist in the community. And so we move on. But that's not actually what the statute says. So let's look at page 98. One of my favorite statutes in all of this notebook that you have here, and I have several favorites. Does that make me a nerd? I might. Should have admitted that. Okay, 33-1255. This statute is almost unchanged from the Uniform Condominium Act that was introduced in Arizona in 1985. And I suppose that's why it still remains somewhat elegant in the way that it's crafted. So here's what it basically says. And if you go to subsection B, it says, all common expenses must be assessed against all of the units in accordance with the allocations set forth in the declaration. So if the declaration says out of 100 units, everybody pays 1/100th, or if it says there are 4 floor plans and you're either going to pay assessment allocation A, B, C, or D based on your floor plan, that's the way you're supposed to do it. The statute, simple, elegant, straightforward. All common expenses must be assessed against the units in accordance with the allocations set forth in the declaration. Then you go to subsection B, and that's where a lot of people stop. They say, well, all common expenses. That's everything, including the $10,000 that fell out of the sky with the lightning or the thunderstorm. But then you go to subsection C, and all of a sudden it gets a little more complicated. And this is the part where most board members and even some managers of condos forget the rules, and we get in trouble. Here's what it says. Unless otherwise provided for in the declaration, declaration is a synonym for CC&Rs, all of the following apply. Number 1, common expenses associated with the maintenance or repair or replacement of a limited common element shall be equally assessed against the units to which a limited common element is assigned. What's a limited common element? It's a common element. It's just a subspecies of common element where fewer than all of the units have use access control of that area. So think balcony or fenced-in porch or something like that. And so what it basically is saying is if the association's obligated to maintain that patio, porch, or whatever, if it's a limited common element as defined in the documents, you have to pass that through to the people who own the limited common element. Have to, must. It says all common expenses associated with the maintenance, repair, or replacement of a limited common element shall be equally assessed against the units to which the limited common element is assigned. Now, for those of you that are one step ahead of me, I'm coming back to the statement in subsection C that says unless the declaration otherwise provides. So parenthetical that, footnote it, we'll come back to it. But the rule in number 1 is limited common element expense, to the extent the association is obligated to maintain it, must be paid equally by the people who benefit from it. And that makes sense. That's what the rule should be because they have exclusive use of it. If you have exclusive use of a balcony and the association has to maintain it, why should everybody else participate in that? Okay, so that's making sense. Number 2, any common expense or portion of a common expense benefiting fewer than all of the units shall be assessed exclusively against the units benefited. So let's go back to our $10,000 lightning strike. We'll concede it's an association expense. It's a roof, exterior, they got to fix it. But now that's a common expense, and we have to say to ourselves, does that benefit fewer than all of the units? It's very straightforward language, not complicated. Does it benefit fewer than all of the units? Yes, simply put, this is not complicated. Now, we're not going to get tied up in esoteric principles like, well, it benefits everybody for a unit not to be exposed to the elements. Okay, that's kind of ridiculous. So it's very straightforward in the statute. It benefits fewer than all of the units. And so we have to go back to subsection C, where it says, unless otherwise provided for in the declaration. So this is beautiful in a way. If you're a developer, you're saying, hey, this statutory framework is awesome. I can do whatever I want. So a developer in the declaration, or CC&Rs, could say, all the unit owners are going to pay equally all common expenses, including the type of common expense that results from maintaining a limited common element. We're not going to pass that through. And all the unit owners are going to pay all common expenses that benefit fewer than all of the units. It doesn't matter. Everybody's going to pay, all for one, one for all. Communal sharing of expenses, no matter the type, no matter the cause. So the question is this: how often do CC&Rs actually otherwise provide on these topics? It's an interesting question. And here's what we find, having done this almost 20 years and seen just about everything. Very few boards and some managers actually know what the declaration says on the topic of these types of common expenses. This very narrow subset, common expenses incurred maintaining a limited common element, or common expenses incurred where the result of the expense benefits fewer than all of the units. And so what's the default position? We foist them onto all the owners equally. And so every once in a while something will come up. Let's say it's the $10,000 example again from the lightning strike and the thunderstorm. And they ask us what to do with this $10,000. It actually comes up because it's a big number. And we say, well, our default position in Arizona is that common expenses that benefit fewer than all of the units are going to be passed through. That's what the statute's saying. The default position is pass it through. So we have to ask one simple question. does the declaration otherwise provide? And there are two different ways to look at this. One is that if the declaration says everybody pays 1/100th of the common expenses, and that's all it says, that's the declaration otherwise providing. That's the declaration saying we intend for all expenses to be paid equally because it says common expenses will be paid by everybody equally. That's one view. And as it turns out, that's the view that we found that most board members and homeowners want, which is kind of odd. You would expect that a board would say, we've got this bucket of $10,000 problem. We really want to be able to push it through to the owner who's benefited because we didn't budget for that. We don't have the money for it. Oddly, or you might think, Scott, it happens all the time, board members say, A, that's kind of unfair to that guy. Back to my point, why it's okay that this all happens, which is he didn't have anything to do with it, it's unfortunate, it's an act of God. And the board members will say, well, we've been paying for that kind of thing for 20 years. If we go with what you're saying, Scott, then I won't get my turn. When it's my turn to need the association, yeah, you'll fix it for me, then you're going to give me a bill for $10,000. So we don't really want to change it. To which I say, it's really not optional. The statute says what it says. So back to my point about two different ways of looking at the declaration. One way is saying, if it says all common expenses are going to be paid equally by the owners, that otherwise provides, and that says distribute them equally. But the other perspective takes a slightly different view. If you look at the statute again, in order for the declaration to otherwise provide, to say something different on the topic of common expenses that benefit fewer than all of the units, this perspective says the CC&Rs need to say, common expenses that benefit fewer than all of the units will be paid equally by everybody in the condominium anyway. In other words, how could the declaration otherwise provide or say something different on a topic unless that topic is explicitly addressed? The topic of common expenses that benefit fewer than all of the units. If the CC&Rs just make a generic global statement that says all common expenses are going to be paid 1/100th by the unit owners, that's not really saying something different than the statute on the topic of 33-1255C2 common expenses. So what's the answer? What's the rule in Arizona between these two slightly different yet important ways of looking at whether the declaration otherwise provides? Does anyone know the recent case that came out? There's no recent case. That's a trick. We don't know. We don't know. But here's our perspective. The Carpenter-Hazlewood perspective is, just so I don't leave you hanging that there's this sort of unresolved ambiguity, we take the second position. At Carpenter-Hazlewood, we believe that the statute is intended to create a default public policy position. The default public policy position is that in condos, when the association incurs an expense that benefits fewer than all of the units, the government has said the fairest thing to do is to pass it through directly to those condo unit owners. And the state has said if you want to disturb that default public policy position, the declaration has to say something different. If that's the public policy, that we fairly pass through the expenses that benefit fewer than all of the units, which actually may or may not be fair to the person who has to pay it, but it's certainly fair to the people that have nothing to do with it. So you can look at fairness a couple of different ways. That if the public policy says that, then in order for the declaration to otherwise provide, it really has to address the topic. So when we analyze these situations, we usually come to fairly straightforward conclusions. It's not the kind of letter that says, well, you know, there's this and there's that, and you can choose this or that. We take a position. And the surprising thing, although it no longer surprises me, is that as a young lawyer, what I expected clients wanted, which was the ability to take this $10,000 and push it through to the person who had the roof problem, actually creates more of a dilemma. Because now you've got to change 20 years of behavior. And Sally says, well, we've been doing this for 20 years, and I've never had something happen where I needed the association, and now I'm not going to get my turn. But we have to resist that kind of thinking because that's not legal thinking. That's just emotional thinking. So that's the pass-through assessment, although I do want to point out two more things that we don't usually talk about because that's got so much sizzle, that whole topic we just talked about, that pass-through thing. There are a couple of other pass-throughs, but I only want to mention one, and that's on page 99, subsection E. I could go on for 20 minutes on this one, I promise you I won't. But look at it, it's so cool in its simplicity. If any common expense is caused by the misconduct of any unit owner, the association may, optional, assess that expense exclusively against that unit. Notice that this is not under subsection C. This subsection E just comes off of 33-1255. It's not a subpoint of anything else. It's a standalone statement. Doesn't say anything about whether the CC&Rs otherwise provide. It's permissive. Every board of every condo in Arizona has the right under the statute, but not the obligation, the option, to pass through to a unit owner expenses caused by the misconduct of that unit owner. Here's the scenario. Guy goes away from ASU or U of A or wherever you happen to be. Imagine that he has a unit that he locks up and goes back to wherever he's from for 3 weeks at Christmas. In the second week, over the holiday break, downstairs unit owner starts complaining about water coming through the ceiling. Eventually, you, the manager, get involved. You end up at the condo. You go into the unit above, and you realize that there's hydroponic pot growing everywhere in the unit. Now, for purposes of talking about this statute, again, let's forget about insurance because that's a complicated insurance problem, obviously. But to me, that's misconduct. You cannot grow hydroponic marijuana in your unit without violating some law or some CC&R provision. And the expense of fixing that, to the extent the association has a role to play in fixing that, you don't even have to get to 1255C2. It's not even about that. It's about misconduct. Growing hydroponic marijuana in your unit at a condo, hypothetically, near ASU, is going to always be pass-through-able under this section. So that's the pass-through assessment RIF. Okay, the second one that you all picked was, we'll skip through the two you didn't. Yes, question.
Would it be beneficial to also point out the assessment clause that's available to insurance as part of that topic?
Yes. In this statute or in a different one?
No, just the fact that homeowners can protect themselves on that type of pass-through assessment.
Good point. So the point is that there may be a way for the owners to insure against these types of pass-through assessments, and that's absolutely right. There's any number of ways that you can insure this, and I wanted to illustrate a statute. It's hard to do it in a way that makes it simple without overcomplicating it with the insurance piece, but you're right. And when the association decides what insurance it's going to have, owners need to make sure that the insurance that they have matches up with the insurance that the association has to make sure there's coverage for those things. That's absolutely true. And a board and a management company could feel better about the possibility that an owner is going to be exposed to risks that they don't anticipate by pointing out that there may be a way to insure against some of these risks. Crystal?
Have you ever had an association at least attempt to amend their CC&Rs to specifically address C2?
Have we ever had a client try to amend their CC&Rs to specifically address C2? And the answer is no, not that I can recall. Perhaps we have, but I can't think of any. It's one of those things where a lot of developers and developers' attorneys didn't think this through. What I like is some developer attorneys who draft CC&Rs, I like what they do. I can tell what they're doing. When they're drafting the CC&Rs, they take the statutes and they just go through a checklist. Like a pilot who always goes through the checklist that's written before they fly, no matter how long they've flown. Good lawyers go through a checklist, they look at the statute, then they contemplate whether to otherwise provide here or not. And once it's there, we find that clients are either stuck with it or they're not. It's rarely disturbed, although it probably should be. Be a great debate to have in a community. Yeah, Katie?
As far as whether it affects more than one unit, has this ever come up with you regarding water pipes in a condominium where the association pays the water and it services maybe 4 units?
Has this ever come up where we've got water pipes that may service 4 units? The answer is yes. That's almost one of the more common ways that it comes up. And when a pipe serves 4 units, we either are going to pass through that assessment to, well, everybody, which is an option, which is the traditional way of doing it. The statute's been here since 1985 and hasn't changed.
Yeah.
Or we're going to pass it through to the 4 or through to the 1. Now, I will admit something to you. Around here, we tend to think of certain issues that come up on a scale of 1 to 10. Sending a demand letter to a delinquent homeowner, we'll call that a 1. Dealing with the intersection between insurance, the pass-through assessment, things that happen, weird ways that water pipes are configured, where the meters are, and trying to figure out the right way to allocate those expenses and interact with the insurance and deal with the deductible. On a scale of 1 to 10, with our expertise, and as long as we've been doing it, we treat those issues as a 9. They are that complicated. And what's somewhat odd about it is that for us as legal professionals, having done this for years with all of the experience and credentials that we have, it's a 9. And what we find is that a lot of times boards, managers, and even some insurance folks think that there's some kind of rule out there, or they got it in their head that, well, that's the association's responsibility. And frankly, it often works. When it doesn't is when the homeowner gets a lawyer who says, I think this is all messed up. Then we get in and we realize it's not just a mess in that particular circumstance, but now we're fighting against 20 years of wrong thinking, bad culture, and horrible experiences. And it's almost as tough to navigate that as anything else. But yeah, water pipes is definitely one of the ways it comes up. All right, let's talk about insurance claims and insurance issues. There's a lot to talk about here, and we have done seminars in the past where we spend the entire hour talking about insurance. And so I'm going to pull out 3 very straightforward insurance issues that we see all the time in condos. The first one is deductible allocation. Deductible allocation. And by looking at 33-1255C2 first, it's the perfect jumping off point for talking about deductible allocation. Why? Because the deductible on the association's insurance policy is a common expense. It's the association's policy. So the association's going to pay the $5,000 deductible in our $10,000 repair scenario. So we had our lightning thunderstorm scenario with the roof and the exterior. Now let's put insurance back into the mix. It's a $10,000 problem total, but a $5,000 deductible. So the insurance company is going to pay $5,001 through $10,000. The association is at least in the first position to be responsible for the deductible from $1 to $5,000. We'll concede that. But let's start with 33-1255C2. If that's a common expense, it is, and if it benefits fewer than all of the units, we need to take that common expense, turn it into an assessment, pass it through to the owner of Unit 20, who had the lightning and the thunderstorm, and they have to pay the $5,000 to the association. Jack says maybe the association owner can get insurance for that $5,000 obligation, which is cool, but that's not really our problem. It'd be nice if they did. But that's where we start with deductible allocation. Now, obviously, based on what we said with 33-1255C2, the question of whether you can force that deductible through to that unit owner is going to have something to do with what the CC&Rs say, because that's what 33-1255C says, unless the documents otherwise provide. So we're back into that inquiry with the 2 types, explicitly addressed or implicitly addressed. We think it has to be explicitly addressed, pass it through. So some associations would stop there, because they don't have to go any further, because the statute says you have to, the declaration doesn't otherwise provide, we pass through the deductible. The other way that this is done is through the CC&Rs, through an amendment, where the association gets everybody together and says we need to do an amendment, we need to modernize our CC&Rs, let's address the deductible. And they get the owners to vote. Hey, if there's ever a deductible under this policy or that policy, the unit owner who benefits from the work done under the deductible is going to have to pay it all. And some associations do that. We love that when we confront a situation. In fact, we're probably not even involved. You have the amendment, you know what to do, you pass it through, it doesn't involve a lawyer. But what if you don't have an amendment and you can't be sure the statute would apply? Can you just make it up as you go? Some do. Some do. The way I phrase the question, of course, I'm obviously implying that that's dangerous. But some do. And that's where we get involved, or that's where you get in trouble, and we end up getting involved on the backside because somebody resisted or something like that. So best practices in this area of deductible allocation. Think it through. If you're a community, or if you're managing a community where the community wants the association to pay the deductible because they want that communal sharing of expenses, what they're really saying is they want the association to be an insurance company. Think about that. That's what they're really saying. I want the association to insure against certain risks and get insurance to cover that. I get that the association can't be exposed to all risks. But the risks that cannot be shifted, simply put, the ones up to the deductible, you're not shifting that risk of loss. We want the association to act as a sort of second insurance carrier to protect me from having to pay even that portion. And that may be okay. But is the community all on the same page about that? Is everybody going into the condo structure on the same sheet of music? Are we all playing the violin together, or are people doing different things? And my experience tells me that very few owners actually think this through. And so the board has a certain assumption, the management has a certain assumption. So if you want to allocate the deductible, 9 times out of 10, the way it comes up is there's a loss, there's a big deductible, and somebody says, who's going to pay the deductible? And now we have to go back and take a look. All right, so that's the deductible allocation piece. There are 2 other pieces within this topic, and we'll go to the next one. I've talked about this before. I'll cover it briefly. Underinsurance, not having enough. We only can have underinsurance if you're not insuring to the extent required by law or the CC&Rs. The most common way that we end up with underinsurance is that the brokers that you're using are not quoting off the CC&Rs. We've been talking about this for 15 years, and hopefully the brokers you're using now will never quote condo insurance without looking at the CC&Rs first. If they are, I don't know how they can be doing their job with you if they're not quoting the condo insurance off the CC&R provisions. It just seems impossible to me. But underinsurance is the concept of not having enough as to what's required. We actually don't call it underinsurance, and I've made this term up, so this is Carpenter Hazlewood legal term. You cannot have underinsurance by not having enough for the risks of the community. That's not what I'm talking about. I'm talking about having less than what's required by your documents. If you have less insurance than what's required by the risk profile of your community, that's just a risk assessment sort of problem that the board has. That's not what I'm talking about. And then the third piece, of course, is, and some of you have predicted it, overinsurance, having more insurance than what is required. And between the two, which is worse? As it turns out, we've seen more problems with overinsurance, having too much. Most recent example, hailstorm in Scottsdale. Association has insurance on certain portions of the building that actually are not owned by the association, are not even maintained by the association. But 20 years ago, somebody came along and said, hey, if we aggregate all of the insurance of the community that the individual owners would have to purchase on the individual market, put it into the association, then lots of money will be saved in the aggregate among everybody. So if everybody's paying, I'm going to make numbers up, if everybody's paying $100 individually for the insurance, but it's $75 per unit if it's under the umbrella of the association's policy, then every unit owner is saving $25 a year. And that's real money, because you're either going to do it or not. So for 20 years, the association has insured things it doesn't own, it doesn't maintain, and everything's fine until there's a massive hailstorm. And now the owners don't have their own insurance. They expect the association's insurance to step in, which they do, in an unsatisfactory way to 5 of the unit owners. They think the roof needs to be totally torn off and redone, and the insurance company adjusts the claim for a repair. Who's in the middle of that problem? The association. They're the named insured. The insurance company's looking at the unit owner and saying, I don't know you. I know your roof, but I don't know you. I'm adjusting your roof claim with the association. And now the association has to decide. Am I going to bug my insurance carrier on behalf of an owner who's making a somewhat extreme argument about the condition of their roof? Or am I going to step aside and let that owner fight it out with the insurance company? You're stuck in the vortex of that problem either way you slice it. So you say to yourself, well, gosh, Scott, I don't know if we're overinsuring. We've got the same policy for 20 years. We haven't never really compared it. We just keep renewing it. may take 20 years for the hail to hit your community, but when it does, all hail's broken loose, so to speak. Thank you. Thank you. Here till Thursday. Oh, wait, today's Thursday. Jane?
Talking about the hailstorm, I had a couple of different condo units where the roofs were covered by the insurance. There's air conditioner units. We don't maintain the air conditioner units. We don't cover them. The insurance company replaced probably a third of them. They're not ours.
Yeah, it's a little weird. Yeah, the point you're making is that in some cases, the association's insurance policy is replacing individual AC units of owners that are actually not the association. So there's only two explanations for that. One is they did it even though they didn't have to because there was no coverage for that, in which case you kind of shrug your shoulders and say, well, that's weird, but the unit owner's got some new air conditioners. The downside of that, the underbelly is now it's a claim on your policy, the association's going to get the increase, and so you're kind of, well, that's nice, but I'm not sure I wanted that. Or, so either it wasn't covered, and they did it anyway, which was a gift, or it was covered and you didn't realize it, but if you don't own them and don't maintain them, that raises a red flag in my mind as to whether or not there is alignment of your policies to the CC&R requirements. And I don't mean to push all of this off onto the insurance brokers. There are a lot of weird situations out there where really the lawyer, the manager, and the insurance broker should get together in a real meeting, face-to-face, the way we used to do it, and pull out the CC&Rs, pull out the policies, and in about 20 minutes, with that team together, it should be able to be resolved quite quickly. The problem is we rarely get those three professionals in the room. We rarely take the time to dig it up. It's not a topic that has a lot of sizzle to the average board. And for the board members in the room, I'm not telling it should sizzle for you. It's not the sexiest topic. That's how we end up with these problems. All right, let's go to who maintains what. The good news here is that the question of who maintains what is simpler than we make it. It's simpler than we make it. The statute, I won't go to it, but in this book there's a statute that talks about maintenance of the community. And what the statute basically says is, look at your CC&Rs. It is possible that the association, this is theoretically possible, rarely happens, it is theoretically possible that the association would be obligated to maintain the unit, and it is theoretically possible that the CC&Rs would say that the unit owners maintain the common elements. Never happens, okay, and it shouldn't. But the law says that the developer has a blank canvas on this topic, who maintains what. But what we find in our practice is that there's a lot of notions out there about this topic based on, and I'll just use a respectful term, tradition. Traditionally, association maintains the roof in a condo. Traditionally, the association maintains the exterior. Traditionally, in condos, ones I used to manage, ones that looked like apartment complexes where the apartment complex owner paid for this and that. All of our experiences in this industry as board members in our community, or the condo you used to serve on in Chicago, the manager who used to do apartments, who's done condos for 20 years, we take all of those experiences and we bundle them up into Scott Carpenter's view of maintenance. Take on a new condo association, and before you know it, we're uttering things like, well, the association always maintains the fill in the blank. This gets us into trouble in two ways. One, the association ends up maintaining something it ought not to, perhaps, or tying this back to where we started, you might be maintaining a limited common element, but forgetting that you have to pass that through, unless the documents otherwise provide, because of your old experience. So when we look at who maintains what, it really is determined by the CC&Rs, not tradition. We don't make any assumptions. And 33-1255-C1, which is that limited common element piece, is an example of why we don't make any assumptions. Now here's one of, there are a lot of assumptions we make. I will highlight one. Maintenance responsibility does not necessarily mean association financial responsibility. I'll say it again. Maintenance responsibility does not necessarily equal association financial responsibility. And all I have to do is point you back to 33-1255-C2, where we started, which is to say, you may be obligated to do the $10,000 fix and pay for it. Money came out of your account to pay the contractor. but the ultimate financial responsibility for that repair may reside with the owner with the pass-through. That's one of the biggest mistakes we make, is we look at a building and say, well, the association's obligated to maintain that. Okay, you might be right about that. Most of the time you are. We don't make huge mistakes in this area. Oh, there are some weird things out there, hybrids and whatever. But we make the assumption that if we have to maintain it, it now falls into that category of expenses. It's going to be distributed 1/100th. And that may not be true for 33-1255C2 as one reason, or multiple other reasons that could exist. And that's where we get into trouble. So what kind of trouble can we get into here? What's the risk? God, you're kind of talking about all this stuff, but what's the real danger? Well, the risk is that the owner of Unit 87 is going to say, I was forced to pay my 1/100th of that $10,000, which means I paid $100 I shouldn't have paid. So what's his remedy? His remedy is, well, aside from writing a letter and screaming at a board meeting, his remedy is to file a lawsuit in Arizona courts for the $100. And I think he's got a good chance of winning, quite frankly, because the way I've set up the hypothetical, the declaration doesn't otherwise provide. The $10,000 was spent. Back to the first version of the hypothetical, there's no insurance. It's $100 per unit owner. He had nothing to do with it, and that owner has a right to assume that the condo is going to follow the law, which sets a basic foundational public policy that says assessments, common expenses that benefit fewer than all of the units are going to be paid by the people who benefit from it, not the guy in Unit 87 who had nothing to do with it. So I think he's got a good lawsuit. So why don't we ever see these lawsuits? Because it's $100. Rational people don't pay a $100 filing fee in justice court to sue for $100. And this is a relatively sophisticated legal topic anyway. I said it's an 8 or 9 on a scale of 1 to 10 for us. So the average owner doesn't figure it out. Or they say, back to where I started with these sort of cultural assumptions, one day it'll happen to me, it's just $100. Now I know the association will be there for me when it happens to my unit. So the risk doesn't really match up with the big deal I've made about this topic, but as lawyers, we got to follow the law, we should do it right, and the statutes are really clear on this topic. The statutes are crystal clear. It's the documents that could throw a wrench into it, the two different ways of looking at it. But the point I want to make here on this who maintains what piece is don't assume the maintenance responsibility means that the expense has to stay with the association. Okay, let's give you 5 fresh topics. And we will cover the top one. So your vote really matters here because we're going to leave 4 topics unaddressed. First one is vendor contracts. And in this topic, we would, if you choose it, talk about what to look for in vendor contracts and sort of the top 5 ways that you all, meaning board members and managers, make mistakes in vendor contracts that result in the lawyer having to incur an hourly rate. Okay, the second one is, what is the scope of mandatory arbitration provisions that we're finding in CC&Rs? That's got some sizzle. I think the first one's better, quite frankly. Impossible CC&R provisions that you literally cannot comply with. What do we do in that situation? It's a good one. Noise and smoke from owners. That's a good one. And utility shut-off. That's 5 great topics right there. And I got some great stuff on these. Shamed for it to all just kind of evaporate. So make your choice wisely. Are you guys voting? All right. You don't want to impact the result. We got some lawyers here who have clickers, and I'm wondering if they're trying to skew this one way or the other.
Condo Summit Part B.
Yeah, we could do Condo Summit Part B. All right, let's see what you did. If it's a tie, I don't know what I'm going to do. All right, noise and smoke from owners. Awesome. Okay, we're going to do noise and smoke from owners. This is a good one. Okay, let me get to that slide so you can see that at the same time. Okay, so when we talk about noise and smoke from owners, I want to talk first about smoke. And we were recently, the College of Community Association Lawyers, which is a bunch of lawyers that are members of Community Associations Institute. We did our national legal conference in Tucson about a week ago. About 500 lawyers were there from across the country. This is one of the top topics of discussion is smoking in units and what to do about it. And I was a little surprised at the breadth of disagreement on the topic nationally, because in Arizona, I see this topic as having a very, very simple result. It's very straightforward to me. But here's the debate nationally. Nationally, and perhaps it comes from different attitudes in different states, perhaps some states that are a little more liberal, when you look at it from the perspective of the smoker, you could get yourself caught in the following kind of logical connect the dots. Guy has a right to smoke. You can do whatever you want to with your body. Just in some states you can't ingest marijuana for different reasons and different things like that. But basically the theory is that everybody has a right to smoke. And that's true in America. You do have a right to smoke. It's not against the law. Although regulated, it's not against the law. If you have a right to smoke, and if your home is your castle, and if your castle happens to be a 1,200 square foot condo unit in a 12-story high-rise in Boston, then if that's your castle and if you have a right to smoke, you have a right to smoke in the unit. And so if you look at it from the standpoint of the smoker's rights from the unit, you could get yourself into a situation where the association's response to the next door neighbor unit owner who's complaining about smoke infiltration between the units, the association could get itself in a position where it kind of convinces itself, oh geez, I don't know what to do. We have to balance the interests of these two unit owners who have equally valid positions. The guy who says I have a right to smoke in my unit, and the guy who says I have the right to ingest smoke-free air in my unit and to not have carcinogens entering my body through what we basically refer to as secondhand smoke. In Arizona, we just typically don't see it as that type of dilemma. And I don't mean us here at Carpenter Hazlewood, although I will admit I do not see it as a dilemma, but in general. And maybe it's because we have so many anti-smoking regulations that have been adopted. You can't smoke in a restaurant, haven't for years. You can't smoke in an office building. I'm not a smoker, I admit that. But I can go weeks without encountering smoke in my world. Get in my car in my garage, come to the office, park, come up here, do my work, go home, and maybe I've got a lame existence, but I do not encounter smoke very often. And so when it comes to the question of can the association impose smoke-free restrictions inside the units, I generally think you can, frankly. I just think you can. Because for a smoker to say, I have a right to smoke in my unit, and I have a right for that smoke to infiltrate my neighbor's units, I just don't think it's a close call. Now, if we have a condo unit where the air filtration system is so good and the separate HVAC for that unit is so separate that a guy can smoke in the unit and no smoke migrates to another unit, that would be different. But that's not what I hear. What I hear is that when people smoke in condo units, almost inevitably the smoke migrates. And it may be subtle, and some people can pick this up other than other people, but the basic view that we have here at Carpenter Hazlewood is that if a condominium wants to go smoke-free, and I mean common elements, pool, clubhouse, and even the units, the only time a smoker is going to have a valid legal argument against the rule that says you cannot smoke inside the unit is if that unit owner can demonstrate that the air filtration and the way the HVAC system works, there's literally no way that that smoke can move. I just don't think that that smoker is going to have much of a legal argument. How do you enforce it? Well, that's the problem. Do you want to put the association in the middle of this issue? The challenge we're seeing across the country, and of course we only practice in Arizona and New Mexico, but what we're seeing in these conversations with colleagues from across the country is that it's becoming a situation where the association doesn't get to make that sort of simple choice that says, well, it's going to be difficult to enforce, so I think we'll just sort of stay out of it. Associations are being forced into the issue by complaining neighbors who complain about the smoke. I don't have time to get into it, but then they make cascading arguments about their emphysema, their own asthma, and now they've got a disability status, and now they want to be accommodated in their disability by having you do something about the neighbor next door, and that's where we get involved, and that goes to a 9.2 on a scale of 1 to 10, when you start involving the disability component of the person who's impacted by the secondhand smoke. So it is difficult to enforce, I concede that. But the alternative of saying we're not involved in this, we're going to stay out of it, you can get away with that for a certain amount of time, but ultimately you'll get drawn in eventually.
We have one that's on the balcony, which is still Condominium, but exclusive use and outdoors.
Great question. What if the smoker is doing it on the balcony? Same thing. I don't really consider it to be much different. And I admit I'm a hawk on the issue, okay? I do not see that the law, and it's not just me or how I feel about smoking, the law does not, in Arizona, we just don't have any law that says smokers have rights. I hate to say it that way, but I'm a lawyer. I'm telling you what the law is. A smoker does not have the right under law to smoke on their balcony in a way that causes smoke that's exhaled from their body or from their cigarette to impact another person's air. So if the association takes the position no smoking in the condo, which means in the unit, on the balcony, on the common elements, in the clubhouse, and you're saying to a smoker you have to leave the entire project to smoke, the law says that's okay. I'm not saying it would be easy to enforce. I'm not saying you'd want to do it that way. That's very dramatic, and that's very draconian, and I've never known a client to do that, but I'm telling you what the law says. Yeah.
It seems to me the basic issue here is that the neighbors are having to smell the smoke. Now, what do you do about a homeowner who has one of these super fragrant candles, and every time she opens the door, it just...
Great question.
And the same thing, what do you do with a homeowner who has fibromyalgia, and the only thing that comforts her is to bathe in Bengay? She opens the door and she backs up to the pool, so we have no smoking at the pool. Now we smell the Bengay instead.
Got it. Well, the question is, it's an excellent question. You know, what if it's not smoke? Maybe it's an aromatic candle. And there was actually a case where in Michigan where some folks were cooking. Well, in Michigan, the issue was because they have a big population of folks who have migrated there. The issue was that they were using extreme spices and other smells of ethnic dishes that were interfering with the neighbors. I mean, you could take smoke and you could insert aromatic situation X. And there's no simple answer to it other than to say that it becomes more complicated when the person is disabled. That's obviously going to become a problem. And you'd hope that the association could simply point at the whole situation and say, hey, this is a dispute between neighbors. Now, if it's just a smell, and doesn't impact potentially the health of the person inhaling that smell, then it's going to be harder. The thing that makes smoke different is that when you actually inhale secondhand smoke, it has a potential carcinogenic effect, which means cancer-causing. I don't know that inhaling, some other fragrant thing is going to cause problems for the person inhaling it. Jane.
My husband has severe allergies to candles, plug-ins, perfumes. He would get near them and it would literally take his breath away and he would have to go outside. So.
Yeah, the point is there's a lot of things that can cause people difficulty. And I didn't mean to get into all of those things because those are more complicated, but sometimes the board needs to bob and weave and sort of try to stay out of those things about, smelly, plug-in aromatic things or whatever. All right, one other point, and then we'll be done. Noise. Noise is actually one of the most difficult issues that associations deal with because you have to measure, is the guy really being loud or is the person underneath particularly sensitive? Whether it's a stereo or walking on the floor or a dog or whatever. And they're almost entirely no-win situations for the board. What we try to do here at Carpenter Hazlewood is help our client, the association, navigate these disputes where one guy wants the association to do X and the other guy wants the association to do the exact opposite of X. How do you win in that? And so helping the association navigate, stay neutral as long as possible, and then pick the right side, frankly. We got to pick the winner. And that's the art that I guess is what causes that issue to be somewhat challenging for lawyers. So we want to pick the winner, and sometimes that's easier than others. All right, thank you for coming. I've got a couple other quick things. Although we didn't cover everything, I do want to point out again that the legislature is in session. There's a lot of crazy bills this year. I'm blogging I'm not quite caught up, so check in tomorrow, and my blog will be caught up. There's a lot of crazy bills, a lot of activity. Love for you to be informed about that. A couple of things coming up. We're basically full for an active adult roundtable. We're going to bring in our active adult 55-plus clients and have a roundtable discussion. And then we're going to talk in March about associations in the digital age. Facebook, LinkedIn, no, not LinkedIn. Facebook, blogs, social media, stealing your association's name and having a mimicked website, chat rooms, boards, things like that. A lot of stuff going on in that area. All right, we'll take questions after. I've got Richie in the back. I've got Mark. I've got Lindsay, Javier, Kelly, and Jeff. You can't miss Jeff. He's in the salmon-colored pants, which is the coolest thing I've seen all day. So thanks for coming, and I hope you have a great afternoon.